Welcome to the I Got Fired podcast, where we help people who've been fired or afraid that they might be. My name is Tom Spiegel. I'm founder of the Spiegel Law Firm, located in Maryland, Washington, and Virginia. Today, we're going to be continuing our series on the processes of the steps in litigation. By that, I mean when you have filed something in court, what happens after that? And we've so far talked about the first step, which is filing the complaint, and then the necessary service on the defendant, which kicks everything into action. And last time we talked about the answer that comes back from the defendant that is required under the federal rules of civil procedure for those of you who may be following along at home. Just before we get started, quick disclaimer, this is intended to be for educational purposes for you. It's not intended to be legal advice for your specific situation. So if you need specific legal advice, then you got it. You should go hire an attorney. So today we're going to be talking about motions to extend time. And I'm putting it after the answer because this is usually the first time that it comes up, although it can happen anywhere in the litigation, and in most cases will happen at least once, if not more times, during the process of getting to trial, or at least getting to summary judgment. And this is under Federal Rule of Civil Procedure 6. If you want to look that up, again, it's a pretty short read, and essentially is as it sounds. It is a motion to extend the time that is already set under the rules of civil procedure. So by that, I mean, in the case of the, federal system, you filed the complaint that gets served on the defendant. When it is served on the defendant, you get paperwork. This is given to you by the court. You get paperwork that says, hey, defendant, you've been served. You've got to respond to this complaint within, I believe it's 21 days. Yeah. Could be wrong. Check the rules of civil procedure. And this can vary. If you're in state court, it could be longer than that. Sometimes you'll see 30 days. But in any event, the defendant has a time frame by which it has to respond to the complaint. And often what will happen, or not infrequently what will happen, is the defense counsel will call up you, or hopefully your attorney, you're represented by your attorney, and say, hey, look, I just got this on my desk. There's only a week left to respond. I'd like to request an extension of another 20 days or something like that. And the reason I think this is so important, I want to do a standalone episode on it, is that this can be a very emotional thing for you as the plaintiff, for somebody who has already been through the ringer. You have already probably been in this process for maybe as long as a year, right? So you had to find your attorney. The attorney, reached out to the other side through some kind of demand letter. There was negotiation back and forth. You filed with the EEOC, again, assuming it's a kind of claim that you have to file with the EEOC, but let's say it's a discrimination claim in federal court. You've done that. You have to give the EEOC at least 180 days to consider that claim before you request your right to sue. And often it will, it may be in your benefit, or it may be part of your strategy and your attorney's strategy, that you're going to let it ride for a little bit because maybe you want to try mediation at the EEOC. So perhaps, let's say by that point, it's been, 6 months, 10 months, maybe even as much as a year before you get to mediation. Mediation failed. You got to wait then to get the right to sue from the EEOC. This sometimes can take months if the EEOC is backed up. I mean, sometimes we have to pester the EEOC and say, look, give us our right to sue because we're ready to go to court. So you get that right to sue. It's probably takes some time to draft the complaint, some back and forth between you and your attorney to get that finalized. The complaint is finalized. Let's say you get it filed, and then it takes, let's say, a week or so, or maybe more. You have 90 days under the rule of federal procedure to perfect service, is what they call it. In most cases, it won't take that long, but let's say it took you a month to finally get the defendant sued. The defendant gets a complaint, and they've got this 21 days to respond. And all of a sudden, here comes the other side, and they're like, hey, we we would like another 20 days. And the reason they have to ask is this is a court ordered deadline. You can't just move it on your own. There are some times in litigation that you can, you can move deadlines on your own, particularly if we're looking at pre-litigation. And let's say that you've got a offer of severance. You've got 21 days to consider it by the terms of the severance, and you hire an attorney or you contact the other side yourself. And you're like, hey, can I have another week to consider this? Well, you don't need, that's not even, it's not filed before the court. That's not a court or a deadline. That's just the deadline made up by the company, and they can change it for whenever they want to, or not change it at all. But once you end up in court, then in many instances, you're going to have to get permission from the court to extend the deadline. Now, and what that looks like is the other side will file a motion, and they're asking for consent, right? They're asking for you as a plaintiff to say, okay, I agree to give the other side, another 20 days or whatever it is to get this complaint filed. If it's a consent motion, they're very short. They're filed with the court. Courts almost always grant them. The court, they're not in a hurry to hear your case. So if it's a consent motion, it's going to get granted sometimes that very same day. So anyway, you get this call from the other side after waiting all this time, after going through what you've gone through to even have a claim. And how the perception, and I've had this happen multiple times in my career, where my client is like, no way, like I am not going, like, why would we give them more time? Like they've been dragging their feet this entire process, and now they had the audacity to ask me for more time. And the inclination is from the plaintiff, at least, to say no. And this is a reason why that's usually a bad idea and is ineffectual, because first, you're probably going to need, as part of your case, at some time during the proceedings, a motion to extend. You're going to need some more time to consider something. Something's going to come up in your personal life. Something is going to come up with your attorney, and you're going to need something from the other side. And if you're playing hardball right out of the gate for something, just so you know, for the non-attorneys out there, this is just a matter of course. Happens all the time. Happens multiple. Courts see them probably multiple times a day. It's not uncommon at all, and it's not considered, except in really extreme circumstances, is not considered, stonewalling or an improper tactic by the other side to ask for a motion to extend. And so, which brings me to my second point, like even if you resist and say no, and let's say the other side, they're still going to file their motion with the court, say we'd like another 20 days. The court's going to grant it. And so, I'm not saying you can't, that you and your attorney can't ever say no to a motion to extend. There are times when that is appropriate, but in that first instance, when the answer gets, when they get served by the complaint, it's not uncommon at all for the defendant to ask for more time to get their answer filed, and oftentimes, for legitimate reasons. So let's say you serve, it's a corporation, and you serve their registered agent, and for whatever reason it sits at the registered agent, then they send it over to the company's contact. Company's contact then sends it to what we call outside counsel. And this is the attorney that's doesn't work for the company, but they get hired by the company. It may be a number of weeks before that complaint lands on his or her desk, and they've got to do their due diligence. It takes them time to call the company, figure out what's going on, to go through, each section of your complaint and answer it truthfully. At least they're supposed to answer it truthfully. That can take some time, and courts know that, and attorneys know that. So when the other side calls you up and says, hey, I'm asking I'd like to file a consent motion for more time, you're probably going to get advice from your attorney that, yeah, this is something we should consent to, even though to you, the plaintiff, it understandably sounds like another, kick in the teeth. You may hear it's taken all this time, the company, and they may have been playing games in one sense or another to try to kind of rope-a-dope you and drag this process out as long as possible. And here they are asking for more time. But, just know that comes as a matter of course. If it's the first ask, you are probably going to look bad if you oppose it. I mean, is the court going to get mad? Is the judge going to get, not really, but it just sets kind of a tone. Again, there may be circumstances where, for whatever reason, you will need to oppose it, and you can talk to your attorney about that. What those circumstances might be, and the attorney can file a motion to, file a motion to file an opposition to the defendant's motion to extend. Again, 9 times out of 10, even if they're opposed, the court is going to grant it. So these kinds of extensions can and often do happen throughout the course of litigation. So, for instance, you've got, and we'll be getting into this in the next section. You've got a discovery deadline. So, the court issues a scheduling order, sets out all these deadlines, and says, hey plaintiff, hey defendant, you guys have to, what they call propound or send discovery, and then you've got this much time to respond to that discovery. And let's say you get one from opposing counsel from the company that's just pages and pages long, and it's taking, let's say you've got a vacation in the middle of that. Like, there could be times when you need some more time to respond to that discovery, right? And so your attorneys, or you are going to go to the other side and say, hey, you've just sent me a discovery request that has, 100 requests for admissions and 30 interrogatories. Again, we're going to be talking about these terms in subsequent podcasts, but and 30 requests for production of documents, and I've got my honeymoon scheduled during the middle of this. Can I get another 30 days? Well, again, if you've come out of the gate, or if you've been fighting the other side all along on motions to extend, then you very well may get that back at a time when you need it. So the moral of this story is that these are not unusual. It's understandably frustrating for you as the plaintiff, especially when they come up early on, right out of the gate from the defendant. But just know that these happen as a matter of course. You might as well even be prepared for it, so don't, you get the complaint served. Don't expect that answer to be served for, let's say another 40 days, 2 months before you get that answer and everything gets started. So don't be surprised if your attorney calls you up and says, hey, we got this motion to extend, I'm inclined to agree to it, and your reaction is going to be, no way, or in less polite terms, you might have some responses that you'd like to send to opposing counsel, but know that the court is almost always going to grant a first motion to extend. You likely will need at some point during the course of litigation. These motions fly back and forth. These timelines are all over the place in civil litigation. So you are likely at some point going to need your own extension of time. So don't get some bad karma by refusing right out of the gate. Again, there may be some extenuating circumstances. I can't think of any off the top of my head, at least for a first motion to extend for the answer. But that doesn't mean that there aren't any. If you want to, for instance, and remember, the court at this point has not looked at your complaint, most likely. I mean, this is all handled automatically on the court side by the clerk and by their law clerk. The court's not looking at your matter. But if let's file a motion, an opposition to a motion to extend, and it's, you file an extensive brief, or as extensive as the court will allow, that shows, let's say, some bad faith on the part of the defendant that's been occurring, for some months. Even if you're going to lose that battle, it might be one worth fighting just to wake the court up, and because the court's going to have to read that, because it's going to have to rule on it. So the judge is going to have to read that, and if you need to kind of draw on the line in the sand, even if you're going to lose that motion to extend, you can start what's called making the record, right? Because remember, the judge doesn't know anything about your case at this point. You've been living it for months, if not years. You know every twist and turn and everything that happened. The judge knows nothing. And so if you can get before the judge early and start getting things what's called in the record, things that are filed in court that the court has to rule on, that might be a situation where even though you're likely to lose that first motion to extend, you're firing an early shot across the bow of the defendant and saying, hey, court, this has been going on for a long time. This is how the defendant operates. And I'm putting the court and defendant on notice, that we're not going to put up with this going forward. But that's pretty rare. It would have to be pretty, egregious circumstances. But look, that certainly happens. We see plenty of defendants who are real bad actors and who do things like that, who do, if not unethical, at least pushing the boundaries, and will play games. Again, most opposing counsel will not do that, but this is before opposing counsel has gotten involved, and sometimes even opposing counsel are like that, unfortunately. So there could be some rare circumstances in which it is worth it, but most times motions to extend are a common part of the process. You as the plaintiff will likely need them. The fact that the defense is asking for them right out of the gate and at other points in the litigation doesn't necessarily mean that it is in bad faith. So there you go. That is the story on motions to extend and how they might play out in your litigation. If you like this sort of information, if you want to get on our list where we'll give you the latest and greatest in employment law, as well as other tips and tricks on how to keep your career on an upward trajectory, please check us out at thecareerrocket.io. Again, that's thecareerrocket.io. If you get on our email list, you will weekly get a free email where we will share many of these types of tips and tricks with you. So for next time, we're going to be talking about the discovery process, and particularly written discovery, and then moving into depositions. So look forward to that. Thanks, everybody, and good luck out there.